The House will now proceed to the consideration of private members' business as listed on today's order paper. Ordre du jour.
Private members' business, resuming debate at second reading of Bill C-304, an act to amend the Canadian Human Rights Act protecting freedom, standing in the name of Mr. Storseth.
So we're going to Edmonton, St. When the House last took up this question in the House, we had 5 minutes remaining for the honourable member for Edmonton, St. Albert, and so we'll continue with that. The honourable member for Edmonton, St. Albert.
Thank you very much, Mr. Speaker. It's indeed an honour and a pleasure for me to continue my comments with respect to Bill C-304, an act to amend Section 13 of the Human Rights Code. Just to briefly sum up some of my observations the last time we spoke, I commented on that firstly, the importance of freedom of speech and how freedom of speech is one of the fundamental concepts that we enjoy here in Western democracies such as Canada. But some of the members opposite talked about the limits of freedom of speech, and I acknowledge that they are there and that they are important. The torts of landers, libel, criminal prosecution for perjury, and of course the hate provisions of sections 318 to 320 of the Criminal Code, I believe, adequately form a check and balance on free speech that crosses the line, especially 318 and 320, which talk about hate speech. But what Section 13 of the Human Rights Code purported to do was create a counterfeit right against hurt feelings, and the sponsor of this bill has talked about that not being a true right at some length. So, Mr. Speaker, we need to be concerned as legislators of mechanisms that are designed to protect liberty, which actually themselves become a threat to liberty. And in my view, that is what we have with respect to Section 13, which was intended to protect against hate speech on telephonic and electronically communicated messages, and by that we're really talking about the internet in the modern age, but which in and of itself has become a threat to free speech. And ironically, there are media reports today of a situation in Saudi Arabia where a 23-year-old blogger has been sentenced to death for comments that he blogged, partially on Twitter and in a blog, where he fancifully cited or described an imaginary relationship that he had with Muhammad. And he described Muhammad more as a friend to him than as a deity. And of course, that offended the clerics in Saudi Arabia, and this individual, for expressing those thoughts through his blog, has been sentenced to death. Now, of course, and thankfully, the sanctions under Section 13 of the Human Rights Code are much, much less tragic and severe than that which are imposed by the clerics in Saudi Arabia. But I think by analogy, members should be concerned that speech which some might find offensive is sanctionable. It is very much, Mr. Speaker, a difference of degree, not a difference of kind. This place, Parliament, where we have unfettered free speech and cannot be subject to prosecution, has to deal with difficult issues from time to time. And in fact, the last time this bill was before the House, almost at the exact same time, there was a court case in British Columbia where the criminal code provisions and sanctions against polygamy were under assault by an individual who had been charged with them. Now, the court in that case upheld the criminal code provisions banning polygamy in Canada, and in my view, rightfully so, but it might have gone differently. The point is, Mr. Speaker, that this chamber has to, from time to time, deal with contentious issues that people believe strongly, and they believe so because of their religion. Polygamy is an issue that some people subscribe to because of their faith. So if we're to have a fulsome debate on the definition of marriage, like this chamber had approximately 8 years ago, it is impossible to do so without perhaps offending people and their religious values. But we have protection in this place. But what about the outside world? As we all know, Mr. Speaker, the internet has become, and social media has become, the fluid marketplace of ideas where people talk and people comment, and everyone with a blog site suddenly becomes an amateur journalist and an editorialist. And almost all members of Parliament participate in these social media forums. I am on Twitter, I am on Facebook, and I think most members are. So these social media mechanisms have become important as we exchange ideas and gauge public opinion to things that we are debating in this House. So, Mr. Speaker, I think it is hypocritical for members of this House to not support this bill because Section 13 prevents bloggers and people on the Internet from engaging in free speech because they could face prosecution simply because they offend somebody else's deeply held personal beliefs, such as freedom of religion. And I'm going to close, Mr. Speaker, with a quote from one of my favorite Prime Ministers, the 13th Prime Minister of Canada, John Diefenbaker. When he introduced the Bill of Rights, he said, "I am a Canadian free to speak without fear, free to worship in my own way, free to stand for what I think right, free to post for what I believe wrong, free to choose those who shall govern my country. This heritage of freedom I pledge to uphold to myself and all mankind." A Canadian free to speak without fear. Certainly that freedom ought to be extended to people who communicate via the Internet. I encourage all members to support Bill C-304 and repeal Section 13 of the Human Rights Code. Thank you, Mr. Speaker.
Honourable member for Argenteuil-Papineau-Labelle. Mirabel, rather.
Unfortunately threatens the preservation of our flourishing pluralistic society. I say this because we can only truly have freedom where every individual of all communities are able to participate in the public sphere without fear of confronting violence. This is the purpose of Section 13 of the Canadian Human Rights Act. It does not impose unreasonable limits on the freedom of expression. Rather, it is a balance of each individual's freedom to live in society without fear. Hate speech insidiously reinforces prejudices. It is a practice of inequality that is inconsistent with freedom. That is, it inhibits individuals from reaching their own full potential, and therefore, I argue, inhibits our society from reaching its potential. Disseminating messages of hate via telecommunications technology is dehumanizing. It reinforces prejudice, encourages hate, and may even prompt or be perceived to justify physical violence. But not just that, Mr. Speaker. Messages of hate are themselves a sort of violence, a communication of widespread violence that causes harm to us all by dividing us through the act of dehumanizing others. This is why it is necessary that we maintain Section 13 of the Canadian Human Rights Act. The Commission deals with hatred, not with criminal acts of violence, and gives society's most vulnerable minority groups access to a mechanism of defending their rights as equal human beings. Religious minorities, women, queer folk, visible minorities, persons with disabilities, recent immigrants, they are the ones that are most often the target of disseminating hate, and are often the people who suffer from multiple forms of systemic inequality, including poverty and exclusion from the legal justice system. They may lack the financial and legal support to persist in a legal case, and in the meantime, without Section 13, their victimization will be allowed to continue unhindered. Mr. Speaker, this is why we have the Human Rights Act in Canada. It provides precipitous protection from dangerous violations of human rights abuses. It would not exist if those that needed protection were already being effectively protected. Section 13 protects against images and words and opinions of hate, which is to say racism, targeted discrimination, homophobia, and grotesque and misleading imagery or information. This is a kind of violence, and we need to be able to say as a society that we cannot accept this. Mr. Speaker, there needs to be a balance struck between the principles of free speech and protection from hate and propaganda. This is why we have a tribunal to inquire into these reported incidents. The law is specifically structured to account for the moral gray zone that can occur in cases of hate. When weighing the rights and freedoms of one person or group against another, there must be room for variance and for each case to be educated in its specificity. The Canadian Human Rights Act, including Section 13, is a vehicle for exactly that process. If we allow it to be disabled by C-304 in cases where violence is being perpetuated, victims will be unable to protect themselves using the Canadian Human Rights Tribunal. Mr. Speaker, freedom of speech is not an unlimited freedom. The pursuit of liberty, as understood as self-realization, requires the balancing and limiting of other freedoms, in this case, that of speech. Mr. Speaker, this debate is about the balance of freedoms and duties that we have as citizens. Section 13 of the Canadian Human Rights Act represents a duty that we have to other citizens not to limit their freedoms. That is, it allows for people to not be discriminated against and therefore to realize their own purposes. This is a form of liberty, and it is precisely the act of balancing this liberty with the freedom of speech that gives us the opportunity to live as a truly free and pluralistic society. Yes, Mr. Speaker, the Constitution protects freedom of expression, but it also protects the safety and liberty for all. Hate groups terrorize, threaten, stifle public participation, and target the most vulnerable members of society. I urge this House to consider the needs and rights of their constituents who are targeted by hate crimes before voting in favor of this bill. Thank you very much for the opportunity to speak.
Resuming debate, the honourable member for St. Paul's.
Thank you, Mr. Speaker. I'm pleased to speak to Bill C-304 and offer my thoughts on why I oppose the repeal of Section 13 of the Canadian Human Rights Act, opposition rooted in the collective responsibility of parliamentarians to eliminate hate speech in Canada. This responsibility does not begin and end with the prosecution of criminal cases of hate propaganda and incitement to genocide, as the member from Westlock St. Paul and the Minister of Justice have suggested. The promotion of equality and minority rights obligates us to also ensure that an appropriate civil remedy exists for cases of hate speech that do not meet the criminal definition. Je ne souhaite pas affirmer que la...
I would like to say that with regard to Section 13, it is a problematic section. The main issue I would like to raise today is that the principle behind maintaining Section 13 deserves the support of all members. However, instead of repealing Section 13, we should instead make the amendments necessary to the Canadian Human Rights Act as suggested by the Canadian Bar Association and the Canadian Commission of Human Rights. We must ask ourselves seriously why the Conservative government refuses to make the changes suggested and prefers to repeal Section 13. I would also like to add that this debate is precocious, given that this matter is still before the courts.
Is without problems. It is indeed. But the central point I'd like to make today is that the principle behind retaining Section 13 is worthy of the support of members, and that rather than voting to repeal Section 13, we should be making the necessary changes to the Canadian Human Rights Act as suggested by various groups, including the Canadian Bar Association and the Canadian Human Rights Commission itself. The summary of Bill C-304 explains that this enactment amends the Canadian Human Rights Act by deleting Sections 13 and 54 to ensure there is no infringement on freedom of expression guaranteed by the Canadian Charter of Rights and Freedoms. I note there is nothing in the bill about the promotion of equality and minority rights. It is written submission to the Common Standing Committee on Justice and Human Rights in January 2010. The Canadian Bar Association explained the vital role that human rights commissions play in eliminating discrimination based on race, religion, gender, disability, sexual orientation, and other groups, and in advancing equality. The brief remark that leading media outlets in this country have advocated the abolition of Section 13 with no acknowledgement of the value the provision brings to enhancing the civic discourse in Canadian society. Of greater concern to the CBA is the fact that the debate surrounding the expediency of Section 13 has become the proxy for an open assault on the very existence of an administrative framework to protect human rights in this country. Critics have decried human rights proceedings as kangaroo courts, which provide only drive-through justice, and advocated that human rights tribunals and commissions should no longer be permitted to operate. We reject attacks of this kind and reiterate forcefully our support for the continued importance of the work undertaken by these human rights bodies to foster human rights in Canada. When the member for Westlock St. Paul spoke to this bill on November 22nd, he argued freedom of speech is the bedrock upon which all other freedoms are built, and therefore is too precious to leave under the thumb of censorship imposed by this system. Without freedom of speech, what good are our other freedoms, we may ask? This argument, however, ignores the fact that there is no hierarchy of rights, as Chief Commissioner of the Ontario Human Rights Commission, Barbara Hall, has said. For its part, the CBA has explained that freedom of expression in Canada is not an absolute value, and that the CBA endorses the view that a properly drawn civil prohibition against the propagation of hate speech is also a reasonable limitation on freedom of expression. Put another way, my colleague from Mount Royal, all free and democratic societies, including the United States, have recognized certain limitations on freedom of expression in the interest of protecting certain fundamental human values. As members consider Bill C-304, they should remember 3 points. First, as I have established, freedom of expression exists within the context of limitations. The Charter itself, in Section 1, allows for limits on rights. Second, the Supreme Court of Canada has already ruled on the constitutionality of Section 13 in its 1990 decision of the Taylor case, in which the court concluded that Section 13(1) is a justifiable limit on freedom of expression with the meaning of Section 1 of the Charter. Hate propaganda undermines the dignity and self-worth of minority, racial and religious groups and erodes the tolerance and open-mindedness which are essential in a multicultural society. The purpose of Section 13(1) is to promote equality and to prevent the harm which hate propaganda causes to targeted groups. This is a pressing and substantial concern. It is heightened importance because it is supported by other sections of the Charter, namely Sections 15 and 27, and by international human rights instruments to which Canada is signatory. Third, while the Minister of Justice has argued that Section 13 is not an appropriate or effective means for combating hate propaganda and that the Criminal Code is the best vehicle to prosecute these crimes, the Criminal Code, sections of hate speech, and Section 13 are intended to be complementary and serve different purposes. Here is how the CBA explains it. The criminal prohibition in Section 319 of the Criminal Code sets an extremely onerous standard. This is appropriate since a criminal conviction for hate speech, like any other criminal offence, carries with it social stigma and a criminal record. Section 13 is for a different purpose, providing remedies to target groups for harm, fostering greater respect for target groups, and changing behaviour, and also applies to conduct that falls short of criminal behaviour, but nevertheless poses harm to vulnerable groups. The CBA concludes that given the importance of freedom of expression, it is appropriate there be a range of options for society to respond to expression that causes harm. Criminal sanctions should be reserved for the worst cases rather than the only option. For these 3 reasons, I believe that a civil remedy for hate speech must continue to exist within human rights legislation. However, as I mentioned at the outset of my remarks, there are indeed legitimate concerns about Section 13 as currently written. While there is not sufficient time to explain each one, I feel it's important to list the various amendments to the Canadian Human Rights Act that have been suggested. As my colleague from Mount Royal has suggested, the CHRA could be amended to include a built-in filtering mechanism through the requirement of the consent of the Attorney General of Canada for launching any prosecution, as currently exists in the Criminal Code, in order to ensure only the most serious cases go forward. As the CBA suggests, complaints should only be made in one jurisdiction at a time, instead of the current practice of simultaneous federal and provincial complaints. As the CHRC has suggested to Parliament, we could add a statutory definition of hatred and contempt in accordance with the definitions offered by the Supreme Court in the Taylor case, as well as a provision to offer for the early dismissal of a Section 13 complaint that do not meet this definition. An additional amendment could also allow for the cost to be awarded in cases of abusive process. The right to face one's accuser could also be added to the Act. And finally, the current provision which allows the Canadian Human Rights Tribunal to assess penalties should be removed in order to retain the remedial and not punitive nature of human rights law. I urge the members to choose this path and ask the government to amend Section 13 rather than to repeal it. Last month, an intern in my office from Toulouse, France, Olivia Kelly-Loncu, gave a presentation on Bill C-304. She said, The freedom of speech does not give the right to vilify and has to be used wisely without undermining Canadian values of equality, tolerance, and fairness. To be free means to be respected as well as to respect others, and in that sense, one's freedom should not harm the freedoms of another citizen. Simply put, one person's personal freedom where another begins. I couldn't agree more. Thank you, Mr. Speaker.
Resuming debate, the Honourable Minister of State, Small Business and Tourism. Thank you. Thank you, Mr. Speaker. I'm very pleased today to be able to rise and to support the bill C-304, the bill put forward by my colleague from Westlock, St. Paul, and I would like to congratulate him. He is a member who defends freedoms, particularly the freedom of expression and opinion. And I can tell you, Mr. Speaker, that my political career is one that has been tumultuous. However, it's something that I always defend is freedom and individual responsibility, and I'm proud to come from the region called La Beauce, which promotes these values, the values that are at the heart of Western society. And today we are talking about individual freedom, and I am pleased to support this bill. Freedom of expression, Mr. Speaker, is the cornerstone of a free and democratic society. We cannot reject that freedom of expression only because we don't like the comments that some people would say to us or regarding society. We judge a society based on its constitution, its legislation, and I'm proud to be Canadian. I'm proud of the Canadian Constitution, and I try as a politician to always act with respect for that Constitution. We also have a charter called the Charter of Rights and Freedoms. So the Charter of Rights and Freedoms in Section 2B defends and promotes freedom of opinion and freedom of expression. We must be attentive to what Canadians say, and Canadians are aware of this freedom of expression and freedom of opinion. So if someone stands up to make comments that I do not like, the most important thing for me as a politician is to be able to say that and to have an open debate and to inform society. There is in our society, or there are in our society, people who have made hateful comments towards groups or individuals. There are also a provision in our criminal code, which is section 319. And in the criminal code, this fights against hate crimes, and this is the best instrument for this. It is not section 13 of the Canadian Human Rights Act. It does not meet those objectives. I just heard my opposition colleagues say that the Supreme Court of Canada, the highest court in the land, had said that this section was unconstitutional and wanted to see amendments. What we want to do is repeal it, because we know that there is a section 319 in the criminal code which will reassure Canadians when there is hate propaganda towards groups or individuals, and Section 13 is subjective. It isn't enough to give Canadians an overall idea or a direct idea of what they should say or not say, and that should be determined by a court, an independent, autonomous court. There are courts that exist, criminal and civil courts, and we have the provisions to guarantee that hate propaganda will always be dealt with as they should through the criminal code. Also, why we want to repeal Section 13 is that Section 13 does not fall under criminal law. When somebody makes comments such as this, they have to prove that they were inciting violence or to disturb the peace and incite violence by one group against another group. And when it comes to Section 13, the individual's intent, the intent of the individual making those comments is not taken into consideration. That is why in a free and democratic society we must abolish or repeal Section 13, which has been challenged before the courts on a number of occasions, and there are a number of cases of jurisprudence that exist in this regard, and our role as legislators is to legislate in order to promote freedom of expression and to ensure that the courts have the tools they need to fight against groups or individuals who want to make those kinds of comments against other groups. And as you know, Mr. Speaker, it is an offense to incite hate through statements in a public space against an identifiable group when this incitation could lead to disturbance of the peace. It's also an offense under the Criminal Code to voluntarily incite hatred against a group of identifiable individuals other than in a private conversation. That is why I am very comfortable supporting this bill, the bill put forward by my colleague in order to repeal Section 13 and to focus solely on the Criminal Code. This is an important day for freedom of expression, and I hope that a number of our opposition colleagues will share this opinion and promote freedom of expression. And this can be done by repealing Section 13. I have no fears that hate comments in Canada will go before the courts and be dealt with as they should be under the Criminal Code. The most important thing is that a number of complaints were filed with regard to Section 13, but that sought to violate the rights of Canadians and to deprive them of their freedom of expression. And we can assure Canadians and Quebecers that freedom of expression will remain protected. No one will be able to use Section 13 in order to violate or prevent somebody from having that freedom of expression. We must also reassure Canadians with regard to comments that can be made against other groups, and this will be dealt with under the Criminal Code. Mr. Speaker, it is important to be able to promote freedom of expression. It is an important part of the Canadian Charter of Rights and Freedoms, and I have a great deal of difficulty understanding the opposition. Some individuals within the opposition, some of my opposition colleagues who are not in favor of this bill. This bill is really fundamental for our society, a society based on freedom of expression. We are here, we speak every day in the House, we can express our opinion, we can have different opinions. There are different opinions about what we want for our country, and Canadians must be able to have these debates publicly without having the sort of Damocles over their heads and perhaps have to be investigated by the Commission because they have made comments that some people consider to be hateful. So today and in the coming days, when we will vote for this bill, we will show Canadians that freedom of expression is something that is important to us and that we will continue to protect that freedom of expression. As a politician and as a politician that shares the idea of individual responsibility and the right to freedom of expression, I can only congratulate my colleague. He is a member who stands up on behalf of his constituents, and he defends the values and principles that are the cornerstone of our Canadian society, and I'm very proud to support him and congratulate him, as do other members of my government, and I want this bill to come into force as quickly as possible. Thank you, Mr. Speaker.
Resuming debate, the honourable member for Windsor, Tecumseh.
Thank you, Mr. Speaker. I'm looking forward to this opportunity to rise to speak on this bill, this private member's bill, C-304. I've had a great deal of experience with this in a number of ways, both here as a parliamentarian and at one period of time in my professional career as a lawyer. Mr. Speaker, in its simplicity, Bill 304 has other sections in it, but what this is really about is the repeal of Section 13 of the Canadian Human Rights Act, and you've heard that from the number of speeches that we've had so far. And this is clearly, on the part of the mover, and I will say generally by the Conservative Party, an attempt to appease some of their right-wing ideologues in the media in particular, but also in keeping with their right-wing ideology of a society that has no government intervention. What this is about for us, who support Section 13 of the Canadian Human Rights Act, is to recognize the nature of what Canada is, what it always has been, not always at its best, but at its best, Section 13 is what Canada is really about. And Mr. Speaker, I think it's really important because you hear demeaning comments from the right wing in this debate about this is really about minor sensitivities that are being offended. It's not what Section 13 is about. I'm going to quote from Section 13.1. And this is about giving the Canadian Human Rights Commission the right to, in effect, regulate and impose sanctions against people that are prepared to make statements in public. The big debate more recently has been around telecommunication debates, but that will make statements on any matter that is likely, and I'm quoting now, that is likely to expose a person or persons to hatred or contempt by reason of the fact that that person or those persons are identifiable on the basis of a prohibited ground of discrimination. We're talking about statements in writing, over the Internet, electronically communicated that will identify groups and draw hatred and contempt to those groups. That's what Section 13 is about, and about prohibiting that type of behavior. Mr. Speaker, I think you have to appreciate, because again we hear this from the Conservative side of the chamber. Well, we can deal with this by the hate propaganda sections, specifically Section 318 of the Criminal Code. I know that section very well, Mr. Speaker. There's only been, to my knowledge, 6 cases that were ever prosecuted under that section, and I did one of them. I have to say, ultimately successfully defended one of those charges. And I have to say, Mr. Speaker, it's relatively easy to use that section in defense of all sorts of heinous type of conduct. But it's like using, depending on that section, to protect vulnerable groups who are being the subject of contempt and hatred. It's like using the mace, Mr. Speaker, to tap in a tap or a little nail. It's a gross overreach. And again, I want to repeat, it's only been, to my knowledge, used 6 times since that section came into effect, and it came into effect sometime, I believe, in the late 60s, early 70s. So it's been in existence for over 40 years now and has been used that few amount of time. It is to be designed and used, and the penalties, of course, are quite severe. It requires in every case for the Attorney General of the province to allow it to be used. And, Mr. Speaker, if we are going to try to defend that section as a mechanism to help protect vulnerable groups in our society who are the subjects regularly, and I think of the Jewish community, who historically, of course, has been a target for anti-Semitic attacks. More recently, the Islamic community, who again have been subject to attacks because of their faiths, both those groups. I think of the Afro-Canadian communities, who have been of a lengthy history of being attacked because of the color of their skin or the continent that they come from. And you can go down the list. And, Mr. Speaker, there are some problems with this legislation, with the Canadian Human Rights Act, but it can be fixed. There are some amendments that could be brought forward that would reform it. I think the other thing that it really needs, Mr. Speaker, is to recognize that we need to develop the jurisprudence around this section. And we haven't done that very well up to this point, and I would admit that, but that can be remedied. Mr. Speaker, what we need are 2 levels. we need the criminal code for the more severe types of hate propaganda. And so the code, Section 318, should remain. It's working for the purpose that it's designed for. But it is not designed to deal with this type of hatred or contempt being brought against identifiable groups. It's just simply not designed to do that. Section 13 of the Human Rights Act is what is purported to be used for that purpose, and what we should be supporting, maybe with some reform. So we need the two tiers in order to be able to have a free society for those individuals who are regularly targeted by anti-Semitic, anti-Islamic. We can go into homophobia as well. But there's any number of other areas where language that is used does draw hatred to that identifiable group, draws contempt to that identifiable group. And we as a society, Canadians as a society, are saying, no, that is not the kind of society we want. We want to be able to have a group, in an organization, a tribunal, Canadian Human Rights Act, to be able to express our contempt for those people who are prepared to do that, put a stop to the use of that kind of material, and in cases like that, impose some type of penalty to express the revulsion that society feels of people who are prepared to use that kind of discriminatory, hateful language against other identifiable groups in our society. And so we need both those tiers. I'm sorry, Mr. Speaker, I'm finding it very distracting.
There are many conversations going on. I'm sure there are a number of members that would like to hear what the honourable member for Windsor-Tecumseh is saying, and so I'd ask your indulgence, if you wish to have conversations, to perhaps use the exterior lobbies. The honourable member for Windsor-Tecumseh.
So, I'm sorry, Mr. Speaker, how much more time do I have? Okay. So, Mr. Speaker, we do need this, this two-tier. I'm absolutely convinced of that. The criminal code, our criminal justice system, is, like the mace, too harsh a tool to be used in the vast majority of cases. Mr. Speaker, I want to address some of the problems with Section 13, and these have arisen. This section has been in the Act since 1977. It's not a relatively new section. It has been amended on a couple of occasions, but when it really became a problem was with the advent of the Internet. And the amount of hate literature that was going across the Internet, and the attempt by the Human Rights Commission to intervene and try to shut some of that down, if not all of it. But to be able again to express for society as a whole to the bigots, the hate mongers, saying that you can't do that, and we do have a mechanism that we're going to use to shut you down. This isn't about a debate over free speech. This type of speech, like slander, like defamation, like libel, we've recognized historically you can't do that. Mr. Speaker, I want to make one other argument in terms of addressing what we're hearing from the government side, because again, they're saying this is an interference, a major interference with freedom of speech. That was the same type of argument that I heard repeatedly through the 60s and 70s as we moved as a society to prevent discrimination in hiring, in residences, and you can go down the list. And you heard, again, usually from the right wing, well, wait a minute, I have a right to discriminate. I don't have to rent my property because I don't want, I happen to be living next door, I don't want somebody whose skin is a different color than mine living next door to me, and I have a right to do that. I don't have to employ this person because of the color of their skin. We've said that is not acceptable in our society, and we have now saying very clearly we keep Section 13. We're saying the same thing about that kind of language being used against those identifiable groups. Thank you, Mr. Speaker.
Resuming debate, the Honourable Parliamentary Secretary to the Minister of Citizenship and Immigration.
Well, thank you very much, Mr. Speaker. I was really looking forward to the opportunity to speak today, and got to wait all day, and now I'm getting my opportunity, so I appreciate that, to stand to speak to this bill. Mr. Speaker, I'm certainly honoured to speak to Bill C-304, which was put forward by the member from Westlock, St. Paul. And I recall, a member from Windsor-Tecumseh will remember that back in the 39th Parliament, when he and I both served on the Justice Committee together, that I in fact had moved a motion at the Justice Committee to take Section 13 of the Act and in fact have our committee do a complete and fulsome review of Section 13 for the very reason that we are standing here today to speak to the issue of repealing this portion of the Act and that the member from Westlock, St. Paul, has put forward. Now, when I was appointed as Parliamentary Secretary, I was no longer unable to sit on the Justice Committee, Mr. Speaker, because obviously as the Parliamentary Secretary of Citizenship and Immigration, I had new responsibilities. But I certainly want to congratulate the member from Westlock, St. Paul, who immediately upon being named to the Justice Committee after the 40th, our 40th election, our 40th Parliament, immediately picked up the issue, pursued it, and he then moved on. After 3 years, he had done a ton of work, a lot of work on this issue as a private member's bill. And that's why we stand here today, Mr. Speaker, in order to do that. And I commend him for his efforts in pushing forward on this very important legislation as a private member. And as all of us know, Mr. Speaker, how few private members' bills are able to actually move forward and receive royal assent and be enacted in law. So it's a special opportunity that he has in front of him, and I certainly think he's done a tremendous job to get it this far. And I also want to speak to a point that the member from Windsor-Tecumseh made, because he spoke specifically about having two tiers when it came to freedom of speech, that there somehow needs to be two tiers in terms of deciding what is or what isn't hate speech. I find that reference or that phrase to be extremely ironic when it is both he and his party's belief that there should be no two-tier health care. That two-tier health care, there only needs to be one tier of health care, and that is the health care that we have now in this country that all of us believe in. But somehow when it comes to freedom of speech, that in fact two-tier is not only something he spoke about, but something in fact that he thinks needs to exist. I think it's a dichotomy, Mr. Speaker, and I would hope that the member from Windsor-Tecumseh will think a little bit about the statement that he made this afternoon in terms of trying to refer to two-tier being not okay on the one hand, but yet acceptable on the other. Either it is or it isn't, Mr. Speaker. You can't have it both ways. And the Canadian Human Rights Act is intended to prevent and resolve cases of discrimination. It is not criminal law. Yet Section 13 has subjected many Canadians to a quasi-judicial process for making statements that are not hate speech. Section 13 is simply not an appropriate or effective means for combating hate propaganda. The criminal code is the best vehicle to do so. Intentional wrongdoing is within the scope of the criminal law, and there are already hate propaganda offences within our existing criminal code. Fact is, it is an offence to incite hatred by communicating statements in any public place against any identifiable group where such incitement is likely to lead to a breach of the peace. It is also an offence to willfully promote hatred by communicating statements other than in private conversation against any identifiable group. These are criminal offences, Mr. Speaker. They are committed only if the Speaker acts with criminal intent. And because they are criminal offences, they carry the full procedural protections of the criminal law, the due process that Section 13 simply lacks. Under similar provincial legislation, Mr. Speaker, John Fulton, a business owner in my riding of St. Catharines, was accused of discrimination. The charges were eventually dropped against him, but John was left with legal bills of roughly $150,000, and he did not have the chance to defend himself. He was never given the opportunity to defend himself. In fact, the Ontario Human Rights Tribunal then said he had no right to compensation for legal expenses, even though the charges, the allegations, were completely and utterly dismissed. Mr. Speaker, Section 13 puts too much onus on defendants. Defendants are not always permitted to face their accusers. Normal standards for the validity of evidence do not apply. The government funds the plaintiff, but the defendant is left to his or her own self. And most disturbingly, the truth, the absolute truth, is not an acceptable defense. With all of these advantages, people have been able to plainly and simply take advantage of this part of the Act. Who and what is censored by Section 13 depends on who has the time and resources needed to pursue a Section 13 complaint. If the point of a Section 13 complaint is only to pursue the Speaker, then this should be done in a more formal system with better procedural safeguards. And I'm standing in this House to make sure that the people of St. Catharines, people like John Fulton, do not have their lives and reputation damaged by this well-intentioned but seriously flawed legislation. We all recognize that a law against hate propaganda is necessary to prevent the evils of discrimination. That within the Criminal Code. Section 319, Mr. Speaker, of the Criminal Code contains 2 hate propaganda offences. These offences do not cover as many groups as Section 13. For example, hate speech based on national origin, age, sex, and mental or physical disability is not covered. It is for this reason that our government introduced an amendment to fill this gap. We are amending Section 319 of the Criminal Code to add national origin, age, sex, and mental or physical disability to the definition of identifiable groups. In fact, it was an opportunity I had to speak to this Section 319 of the Code very recently, Mr. Speaker. This means that it will now be a criminal offence to publicly incite and willfully promote hatred based on these grounds. This means our government is protecting the rights of minorities while preserving the right of free speech. Dean Stacey, the lead investigator at the Human Rights Commission, once testified that freedom of speech wasn't given any value. That is simply unacceptable, Mr. Speaker. The best way to fight bigotry is to ensure that we protect and enhance our fundamental freedoms. We must especially protect freedom of speech, which is the very bedrock of our parliamentary democracy and the democracy of this country. Mr. Speaker, in practice, Section 13 is conflicted with Section 2B of the Charter of Rights, which guarantees that everyone has a freedom of thought, belief, opinion, and expression. While Charter rights are subject to reasonable limits prescribed by law, Section 13 does not clearly describe these limits, and this has led to highly subjective interpretations of freedom of expression. The wording in the Human Rights Act leaves it so unclear as to what constitutes an act of hatred or contempt that former Liberal Member of Parliament, Keith Martin, rightly described it as, and I quote, a hole you can drive a Mack truck through. This is why Section 13's overly broad hate speech provision was ruled to be unconstitutional in 2009. Mr. Speaker, we need the Canadian Human Rights Act to preserve our rights, not to take them away. We can't allow one badly written section to undermine a defendant's right to due process and the free speech of every Canadian. Mr. Speaker, on behalf of people like John Fulton, who have had their rights challenged by a Human Rights Commission, I ask all members of this House, regardless of party and partisanship, because it speaks to the freedom, the very bedrock of our democracy, Mr. Speaker, to support Bill C-304. We will create a system where charter rights like freedom of expression and due process are valued and minorities are protected by our criminal code. Mr. Speaker, thank you.
Resuming debate.
We'll now invite the honourable member for Westlock St. Paul for his right of reply. The honourable member will have 5 minutes. The honourable member for Westlock St. Paul.
Thank you very much, Mr. Speaker, and I'd like to first start out by acknowledging all my colleagues who have stuck around and participated in this debate. It is Valentine's Day, so I'd like to thank them and their spouses for allowing them to be here to participate in it. And of course, I would like to thank my lovely spouse who is here supporting me tonight, giving up part of our Valentine's Day. Mr. Speaker, the purpose of this bill is to protect our fundamental freedoms. The core freedom, the pillar of our democratic society, is the freedom of expression. And now it has been argued on the other side that all freedoms are about equal, but without the freedom of expression, truly, the freedom of religion, the freedom of assembly, they really have less value if you don't have freedom of expression to go with it. This is the tool that all truly free and democratic societies use to push the societal norms. Open debates in our society are not just necessary, they are imperative to having a healthy and free Western democratic society. Open debates are what this place was built on. It is what our society was built on. Now, I know that the member from Malpeque doesn't like open and free debates, and that is why he tried to hold Western Canadian farmers away from freedom for so many years. But now, Mr. Speaker, I would like to take the time to address some of the opposition concerns to this. First of all, the Liberal Party really have come forward today and said, you know what, there needs to be, the Section 13 is very important, and protecting against hate speech is critically important, but it's not so important that we should actually have any penalties for those that break it. That's actually what they came forward today and said. The NDP have said that every member of the NDP caucus that has stood up has used the excuse that the burden of proof is too great, that the burden of proof under the Criminal Code of Canada is too great, that it's too complex, and they propose to have 2 tiers of hate speech. And I, for one, don't necessarily understand that. I don't understand how you can have one tier of hate speech that's worse than another tier of hate speech. What we need to have in our society, and when you talk about the burden of proof and you try making it easier, what you are giving up as Canadians is some of your natural rights as Canadians. What they are asking Canadians to give up is the right to an attorney, the right to a speedy and fair trial, the right to face your accuser. Heck, they're even saying that you shouldn't have the right to defend yourself with the truth. The truth should not be a defense in this country. And when my constituents hear about this, when they hear about these quasi-judicial courts, they're absolutely appalled. And that is why I believe it is important that we as Canadians stand up, we defend our civil liberties, and we say that it is time to repeal Section 13 of the Canadian Human Rights Act and make sure that these types of trials happen in an open, fair, transparent system called the Criminal Code of Canada, where there are checks and balances that Canadians have already approved of. Ladies and gentlemen, this is what the core message is for Bill C-304, Protecting Freedom. The last thing I would like to address, Mr. Speaker, is the hesitancy I see on the opposition benches. Now, I know there's a lot of new members of Parliament in this place, but when I look at the weak arguments of burden of proof, I see people that have already been told by their whip how they're going to vote, so they need to try to formulate a reason why they're going to vote against it. What I would ask members of the other side to do is please throw off the shackles of your whip. This is a private member's bill. Please stand up and vote the conscience of your constituents. I have consulted my constituents on this bill. I hope all members will consult their constituents before they take the time to vote on this, because protecting our freedom of speech is one of the greatest things we can do in this country. Thank you, Mr. Speaker, and God bless.
Order. Order. The question is as follows. Mr. Storseth, seconded by Mr. Rathgeber, moved that Bill C-304, an act to amend the Canadian Human Rights Act protecting freedom, be now read a second time and referred to the Standing Committee on Justice and Human Rights.
Is it the pleasure of the House to adopt this motion? All those in favour of the motion, please say yea. All those opposed to the motion, please say nay. In my opinion, the yeas have it.
Pursuant to Standing Order 93, the division stands deferred until Wednesday, February the 15th, tomorrow, 2012, immediately before the time provided for private members' business.